Today's webinar is titled Navigating the Interactions Between Workers' Compensation and the ADA. We have other webinars established that give more in-depth viewpoints on the legalities and regulations for both workers' comp and the ADA. So this is building on that previously established understanding. And any questions that you have throughout, please submit those via email to me after the webinar. It's just really hard to respond in real time during the webinar. I do have to give a disclaimer that the information presented is current and accurate as of this date, but with ongoing changes, perhaps this could change. So the relevant information for you in a period of question should be readdressed. In addition, depending on the state in which you reside, things could change and be adjusted just slightly, considering workers' compensation issues and other protections for those with disabilities. So this is for general knowledge, subject to change. We'll begin this series today with part 1 and then conclude with part 2 next month. And we'll begin today with the interaction between Title I of the ADA and state workers' compensation laws. The purpose of Title I of the ADA is to prohibit employers from discriminating against qualified individuals because of a disability in all aspects of employment. We've learned that from other webinars. On the other hand, the purpose of a workers' compensation law is to provide a system for securing prompt and fair settlement of employees' claims against employers for occupational injury and illness. So while the purposes of the two laws are not in conflict directly, the simultaneous application of those laws has raised questions for the EEOC and for employers, certainly, and for individuals with disabilities in a number of areas. The presentation, to kind of give a roadmap here, will, for today, begin with this part 1 as previously indicated, and under that we'll address whether a person with an occupational injury has a disability as defined by the ADA. Second, we'll address disability-related questions and medical examinations relating to occupational injury and workers' compensation laws, and we'll conclude with the hiring of persons with a history of occupational injury. So first up, whether a person with an occupational injury has a disability as defined by the ADA. The question is, does everyone with an occupational injury have a, quote, disability within the meaning of the ADA? A reminder, the ADA defines disability as a physical or mental impairment that substantially limits a major life activity, a record of such impairment, or being regarded as having such an impairment. The answer to the question of does everyone with an occupational injury have a disability within the meaning of the ADA is no. First, even if an employee with an occupational injury has a disability as defined by a workers' compensation statute, he or she may not have a disability for ADA purposes. And second, the impairments resulting from an occupational injury may not be severe enough to substantially limit a major life activity, or it may be temporary, non-chronic, or have little or no long-term impact, which we would know would otherwise be excluded. Does everyone with a workers' compensation claim have a disability under the record of portion of the ADA definition? Remember, record of disability under the ADA will be a qualified disability, and so we would look at that just as someone else that has an apparent disability. So with a record of a disability, does everyone with a workers' compensation claim have a disability under the record of portion of the ADA? So I think an example is going to make this make sense the best. A person, let's say a man who is in line for a promotion, has a history of cancer treatment. And although he's now free of cancer, he's not given the promotion because his bosses are worried that if the cancer returns, he won't be able to do the job. He does not at this point meet the first part of the definition of disability because he does not have a physical or mental impairment that substantially limits one or more major life activities. However, based on his record of a disability, he is discriminated against and he would be considered protected under the ADA. So I hope that provides a little bit of context. The answer to this question posed at the beginning here is no. You know, a person who has a disability under the record of portion of the ADA definition, I'll say a person who has a disability under the record of portion of the ADA definition would only be qualified if he has a history or has been misclassified as having a mental or physical impairment that would substantially limit the major life activity. And in this case, although the cancer may not be in remission, he may not actually be having a qualified impairment. He certainly is regarded as having one, has a record of one. Keeping in line with our hope to keep webinars at 30 minutes, I will be moving fast here. So if at any point in time you need to come back to a particular slide or have a question about a particular slide, just note that and send me an email. But this does build upon previous webinars. So this can be confusing for those that are newcomers, but I would just say confer with the previously established webinars, and this will all set context. Moving forward, when does a person with an occupational injury have a disability under the regarded as portion of the ADA? It is if she or he has an impairment that does not substantially limit a major life activity, but they are being treated by the employer as though there is a substantial limitation. Or B, the person has an impairment that substantially limits a major life activity because of the attitude of others towards the impairment. So that subjective viewpoint of what we think someone's impairment then deduces. Or if the person has no impairment but is treated as having a substantially limiting impairment, so sort of similar to the second one there. Now let's take up a few examples because those were a lot of words and we might be confused. Example A, an employee has an occupational injury that has resulted in a temporary back impairment that does not substantially limit a major life activity. So back pain, no substantial limitation of a major life activity. If you're wondering what a major life activity is and what would be qualified as that, just as a quick refresh, it would be something that we do on an ordinary daily basis, like the ability to breathe or walk. For a full comprehensive overview of that, you can visit one of my webinars on the ADA. So in line with example A, bad back, no substantial limitation though of a major life activity. The employer, however, views this person as not being able to lift more than a few pounds and refuses to return her to her position because of that viewpoint. What would the answer be there? The employer regards this person as having an impairment that substantially limits the major life activity of lifting, and the employee then would be protected under the ADA because of that viewpoint of the employer. So you can see that the viewpoint of the employer on someone's perhaps a previous occupational injury or at a previous company or a current one at your own place of work can end up having the effect of that person being covered under the ADA, which we know would then have further impact in other regards. So let's take up another example B. An employer refuses to allow an employee whose occupational injury results in a facial disfigurement to return to his position because the employer fears negative reactions by coworkers or customers. Here, the employer regards this person as having the impairment that substantially limits the major life activity of interacting with others and working. So yes, this person would then be would have a qualifying disability as defined under the ADA. And finally, example C, an employee is fully recovered from an occupational injury that resulted in temporary back impairment. The employer fires the employee because it believes that if he returns to his heavy labor job, he will severely injure his back and be totally incapacitated. Think about that one. It comes up a lot, and I want you to take a moment here of silence to think about this and what you would believe the right answer would be. So here the employee would have a disability as defined by the ADA, and it's because the employer regarded the employee as having an impairment that disqualifies him from a whole class of jobs, those class of jobs being heavy labor. And therefore, there's a substantial limitation in the major activity of working. So we see that we can have a major life activity under example C is the activity of working. Under B, we had interaction with other humans, and A, we had the major life activity of lifting. And it's been because of the employer's viewpoint of the employee in each of these regards that they cannot do something that has then created that protection under the ADA for them. And I will make a side note that, sometimes perhaps, say example A, the person actually did have, a back impairment and it actually did substantially limit a major life activity. Well, then that's easy. We know that they're covered under the ADA. But these three sets of examples are to kind of highlight that our viewpoint of a person matters in whether they would be covered under the ADA. So this kind of goes into disability-related questions and medical examinations relating to occupational injury and workers' comp claims. We'll start with a very common question, which is, when may an employer ask questions about an applicant's prior workers' compensation claims or occupational injuries? An employer may ask questions about an applicant's prior workers' compensation claims or occupational injuries after it has made a conditional offer of employment, but before employment begun, as long as it asks the same questions of all entering employees in that same job category. So, once you get the information, the question is then how do you use it? For example, if you find a pattern of filing workers' compensation claims, can you rescind the offer? I'd say maybe. It's recommended that an offer may only be withdrawn under very limited circumstances, and those situations, could include where an applicant has maybe lied about workers' comp history, or has a history of filing false claims, or past claims demonstrate that there's a direct threat under the direct threat evaluation for safety purposes. But this is not a decision to undertake on your own, so I definitely advise that you consult with your relevant attorney, or consult with me on this, because you're not quite firing someone in these instances, which is hence a tangible employment action, which triggers lawsuits. So you're not quite firing them, but you're close. You're denying them employment. When may an employer require a medical exam of an applicant to obtain information about the existence or nature of prior occupational injuries? We have a little set of questions here for you. So let's take a look at A. Would it be after the application is submitted but before the interview? Or B, after the application is submitted but after the interview? C, after the application is submitted, the candidate is interviewed and employment begun? Or D, after the application is submitted, the candidate is interviewed and offered a conditional offer of employment but before employment begun? Well, the correct answer would be D, and after a conditional offer of employment but before employment begins. I will note importantly here that we need to be consistent with doing this with all entering employees in the same job category. So if we're going to require a medical exam of someone, and you say, all right, Colt, I have the application and I interviewed them, I give them a conditional offer of employment, they have not yet started working, so I can require them to go have a medical examination, right? And I would say yes, as long as as long as that's reasonably related to the needs of that position, and B, we do that with all of the people that we hire for this position. So there needs to be consistency with that, and it needs to make sense for the type of position. Next, with a conditional offer of employment, may an employer obtain information about an applicant's prior workers' compensation claims or occupational injuries from third parties? And third parties here I've noted is like former employers, state workers' compensation offices. Some services provide workers' compensation information. So we have A through D again. A being no at At no time may the employer obtain such information. B, no, unless a conditional offer was made and the candidate accepted. Or C, no, unless a conditional offer was made, the candidate accepted and work begun. Or D, yes, as long as a conditional offer was made. I'll let you just think about that for a moment. We've got the question started with a conditional offer of employment, may an employer obtain information about that applicant's prior workers' comp claims or injuries, importantly from third parties. So should we ever be asking former employers on that resume, calling them up and asking them, are we permitted to talk to them about workers' comp claims or previous injuries with that employee, or even state workers' compensation offices? The answer to this is no. At the pre-offer stage, as at any other time, an employer may not obtain from third parties any information that it could not lawfully obtain directly from the applicant. That said, stay tuned, because in a few more slides, we'll talk about times that we might subsequently obtain information about previously sustained injuries, which we'll need to assess whether those previous injuries would pose a direct threat, if the person were to have the position for which they applied. There are times where we need to know, like, can this person do this without posing a direct threat? So I will talk about how we would find that information out, but just note that we would not be finding that information out from third parties. So basically meaning anyone other than the employee. But then again, we want to be careful. We don't just straight away ask the employee that. We do it based on certain circumstances, which we'll cover in just a moment. Next question, may an employer ask disability-related questions or require a medical examination of an employee either at the time he experiences an occupational injury or when he seeks to return to the job following such an injury? Yes, in both of these instances, provided that the disability-related questions or medical exams are job-related and consistent with business necessity. This requirement is met where an employer reasonably believes that the occupational injury either A, will impair the employee's ability to perform the essential functions, or B, raises legitimate concerns about direct threat. I'll note that, questions and examinations, though, must not exceed the scope of the specific occupational injury and its effect on the employee's ability, with or without a reasonable accommodation, to perform the essential functions. So we want to be careful about scope here, and not to be too broad. May an employer ask disability-related questions or require a medical examination of an employee with an occupational injury in order to ascertain the extent of its workers' compensation liability? Yes, the ADA does not prohibit an employer or its agent from asking disability-related questions or requiring medical exams that are necessary to ascertain the extent of its workers' comp liability. However, here's the however, the questions and exams, must be consistent with the state law's intended purpose of determining an employee's eligibility for comp benefits. An employer should not be, an employer can't use an employee's occupational injury as an opportunity to ask far-ranging disability questions, or to require unrelated medical examinations. The examinations and questions need to be limited in scope. They need to be specific to occupational injury and its impact on the individual, and may not be required more often than is necessary to really determine an individual's initial or continued eligibility for workers' comp benefits. So excessive questioning or imposition of medical exams may constitute disability-based harassment, which obviously is prohibited by the ADA, among other things. But so it's a fine line there, but the answer is yes. If an employer with a disability-related occupational injury requests a reasonable accommodation, may the employer ask for documentation as to what that disability is and what the limitations are? The answer is yes. If an employee with a disability-related occupational injury requests reasonable accommodation and the need for the accommodation is not obvious, the employer may require reasonable documentation of the employee's entitlement to reasonable accommodation. While the employer may require this documentation showing that the employee has a covered disability, then also stating what functional limitations there are. The employer is not entitled to medical records that are unnecessary for the request of that reasonable accommodation. And also note that if the accommodation need is obvious, then we also don't need nor are we permitted to get documentation. So if the need of an individual is obvious to us, based off of some physical perhaps limitation, I think is the easiest example that we could foresee this. Then we probably don't need to go and get verification of that. But this really lies more with those requests that we're not so certain about. And instead of diving deep into the person's medical history ourselves, we just say, hey, we need you to go get a medical cert on this, and that way your medical provider can tell us what you reasonably can and cannot do, and bring it back to us, and let's see if we can't get an accommodation here. And then we look for that reasonable accommodation for those limitations. Does the ADA's confidentiality requirements apply to medical information regarding an applicant's or employee's occupational injury or workers' compensation claim? Well, the ADA allows disclosure of this information only in the following circumstances. So supervisors and managers may be told about necessary restrictions on the work or duties of the employee and about necessary accommodations. First aid and safety personnel, if the disability might require emergency treatment. Government officials, of course, investigating. Employers may give information to state workers' comp offices and things of that nature, and may use also the information for insurance purposes, of course, like for healthcare assessments and renewals and things like that. But this is sort of the limited universe in which medical information about an applicant or employees' occupational injuries or disabilities or workers' comp claims can really be shared. So the last section of today's presentation is hiring of persons with a history of occupational injury. We all know that people apply for a position, they have what we end up finding out often later on, they have a history of occupational injuries, and of course, which can create liabilities for the employer long term. So I think this is a pretty common issue for employers. So we'll start with this. May an employer refuse to hire a person with a disability simply because it assumes, correctly or incorrectly, that he poses some increased risk of occupational injury and increased workers' compensation costs? Generally no. Where an employer refuses to hire a person because it assumes, whether they're right or wrong, that because of a disability, that person poses merely some increased risk of occupational injury and therefore increased workers' comp costs, among other things. The employers, really discriminate against that person on the basis of disability. The exception is where the employer can show that the employment of the person in the position poses a direct threat. The employer can refuse to hire the person only if it can show that in this person's employment in this position poses a direct threat. And so that means that an employer may not, we can't be erring on the side of safety simply because of a potential health or safety risk. Rather the employer must demonstrate that the risk rises to the level of a direct threat. In enacting the ADA, Congress sought to address stereotypes regarding disability, including assumptions about workers' compensation costs. So when I say we're not erring on the side of safety here, just remember that, because it's an opposite to what normally we would say in regards to, I suppose, safety regulations. We're not doing that here. We're not having sort of a decided approach, even if we're right about that approach. We're not having a decided approach based off of someone's disability that they would end up causing that position an increased risk. But we can be aware of it and we can do things about it but we're not going to have a decided opinion about it. We're going to proceed with medical evaluations, etc., ensuring that we're following the guidelines of when we can do that and how we do that, which we talked about in the past few slides and we'll continue to talk about. But I want to mention a little bit more about direct threat because I think it's important. A direct threat means a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. We do have a determination sort of evaluation as to whether a direct threat exists, and we evaluate that based off of fact-based individualized inquiries that take into account specific circumstances of the individual with a disability. So in determining whether employment of a person in a particular position poses a direct threat, I listed some factors to be considered. We look at the duration of the risk, the nature and severity of the potential harm, the likelihood that potential harm will occur, and the imminence of potential harm. Again, not expecting that anyone will just retain that in their brain indefinitely, but at least you know that when these situations come up, that it causes certain required analyses, and you can confer with the appropriate person on that before making a decision on the matter. So here's another question related here. May an employer refuse to hire a person with a disability simply because he sustained a prior occupational injury? No, the mere fact that a person with a disability experienced an occupational injury in the past does not by itself establish that his current employment in the position in question poses a direct threat. Moving forward, I'd say consider the following factors regarding a prior occupational injury and applying the direct threat analysis. It's similar to some of those factors that I had 2 slides ago, but we look at whether the prior injury is related to the person's disability or is it just completely, separate. Because it's really easy for our brains to say, oh, well, this person had these prior injuries, and they have this disability, and they're just, it's a threat for this work environment for themselves. Well, we need to look at whether, first of all, their prior injury even has anything to do with their disability. We also need to look at the circumstances surrounding the prior injury, so the actions of others in the workplace or the lack of appropriate safety devices or procedures that may have contributed to it. We also want to look at the similarities and differences between the position in question and the position in which the prior injury occurred. So if the prior injury or if the prior position may have involved hazards that are not present in this position, then we can't relate that. Also, when you look at whether the current condition of the person with a disability is similar to his or her condition at the time of the prior injury, if the person's condition has improved, the prior injury will have little significance. And it shows that we're sort of retaliating against them for a prior claim of injury when we're using that as saying, oh, it's not safe, you've had this prior injury, yet they get a medical eval that says they're good to go, and we're still saying, well, you had that prior injury, and we're trying to say, see, it's likely going to get worse because of that. If the medical eval does not say that, then really we're not legitimized in saying that either. So we need to look at whether the condition is improved and they're fully approved to move forward. We also look at the number and frequency of prior occupational injuries and the relatedness between them. We look at, of course, the nature and severity, that's common sense, and the amount of time also that the person has worked in the same or similar position since the prior injury without subsequent injury. And we shouldn't be relying on that one time that, Bob did this and I sustained an injury, 4.5 years ago that really doesn't matter with regards to today's work. Now it's different, if it does impact today's work, but we can't just say that we think it's likely that it could. We need more evidence than that. And whether the risk of harm can be lowered or eliminated by reasonable accommodation. It's one thing that we always forget about. We remember that about, ADA related things, but we also need to remember, could this risk or harm be eliminated by reasonable accommodation? Considering so many workers' comp injuries, we'll say not so many, but a fair share could, through different ways, be ADA covered. Certainly not all by any means, but some. And so we need to see if whether that injury or previous injury or how we view that person, if that's, if it's going to cover them under the ADA, because then that's going to invoke reasonable accommodations, whereas we may not have had to provide those otherwise, without that ADA covering. So we'll end this webinar with just a few examples. I know we've come up on about a half hour here, and so we'll keep it quick. First example is Caleb is an applicant. He applies for a position with operating a large saw with a lumber mill. And after making a conditional job offer, the lumber mill discovers that Caleb, who has an insulin-dependent diabetes, was seriously injured while operating a similar saw for another lumber mill. The injury was caused by the failure of a safety device and was unrelated to Caleb's diabetes, but the employer, the lumber mill, assumes that the injury was related to the diabetes and refuses to hire him because of safety reasons. Because of that, they believe he'd pose a direct threat to himself and others in the work environment. Here, Caleb's prior occupational injury was unrelated to his disability, so it does not constitute evidence that he poses a direct threat in the saw operator position because of his disability. If the employer refused to hire him, absent other legitimate reasons, not cover-up reasons, but other legitimate, obvious reasons, the employer would be held liable. Next example, Kurt, he has a shoulder disability. He applies to a restaurant for the position of busser, which requires frequent carrying of basins full of dirty dishes weighing up to 50 pounds. And after a conditional offer is given to him, restaurant discovers that Kurt has had 5 serious injuries to his left shoulder while carrying these basins full of dirty dishes and other busing jobs over the past 4 years. Suspicious, huh? Well, a medical exam and fitness tests show that the condition of Kurt's shoulder has significantly deteriorated with each injury. It also shows that if Kurt carries heavy basins, there's a high probability that his left shoulder will be immediately and permanently injured to the point where his left arm will essentially become useless. Assume there's no reasonable accommodation that will enable Kurt to perform the essential functions of the busing position. Apparently, this restaurant does not have the push carts like the flight attendants have. So the objective medical information and other evidence supports a finding that Kurt's employment in the position as a bus person, as a busser, poses a significant risk of substantial harm. We have other evidence here that helped us determine this. We looked at the number and frequency, nature, and severity of the prior injuries. We looked at the similarity of this position and the previous positions in which the injuries occurred. We looked at the progressiveness of the condition, that progressive deterioration of Kurt's shoulder with each injury, and the evidence that a further injury will render Kurt's arm essentially useless. It doesn't have to be to that degree. We don't have to say his arm has to get chopped off for it to be able to be a direct threat, but certainly the more substantiating the progression of that injury is, the more legitimate we are in our understanding and opinion that he poses a direct threat to himself. And the evidence, further shows that the risk can't be lowered through a reasonable accommodation. We ain't got those push carts that the flight attendants got, so he can't be pushing the bus tubs around. He's got to be holding them. Let's end with here example C. Gavin applies for a position as a laborer at your construction company, and this position does require some heavy lifting and other items up to 100 pounds. And after making a conditional offer of employment to Gavin, the employer requires him to undergo its standard medical examination. Okay, so far so good. As a result, the employer discovers that Gavin previously injured his back while working for an automotive repair shop. Gavin's prior on-the-job injury, which occurred when Gavin was helping a coworker push a stalled car, was not serious. He's completely recovered since this back injury. Nevertheless, employer rescinds its offer of employment because it is worried about increased workers' comp costs and considers Gavin to be a poor risk for heavy labor. His prior occupational injury, which was not serious and which occurred in a position involving hazards not present in this position, does not constitute evidence that employment of Gavin in this labor position would pose a direct threat. So I think that this is a good example in which we did everything right as far as interviewing him, offering him a conditional offer of employment, and we have, all of our people in the position that he's applying for as labor go through a medical exam. He takes the medical exam. We find out that he did have a prior injury, but it doesn't appear that, there's any limitations because of that. It is what it is, and we nonetheless think that because he did have some prior injury, that he would be a higher risk for us, and so we would choose not to hire him. That would be improper, and you could be held liable. So on that positive note, we'll end here. Thanks for joining. We'll see you next time.